The rise of ESG. I'm here to talk today about the Shell case. Have you heard about it? That case casts a spotlight on the realities and impacts linked to the rise of ESG values in the corporate world. Let me give you the background. On May the 26th, 2021, the District Court in The Hague delivered a ruling in the climate change case filed against Royal Dutch Shell plc, whom we shall call by the name Shell, by a group of NGOs and private individuals. These applicants asked the court for three orders. One, they asked that the court rule that the Shell's yearly volume of carbon dioxide emissions was unlawful and must be reduced. Number two, they asked for a declaration and an injunctive order. You know what an injunctive order is, isn't it? It's an order preventing a party from doing something or to stopping them from doing something. And what they asked was that Shell should reduce the net carbon dioxide emissions of the entire Shell group, including the energy products sold, by 2030 by 45%, 35% or 25% compared to 2019. Now, net carbon dioxide emission means the emissions from Shell and from fuels and other energy products that were sold to customers. They can be lowered by the emissions that are captured and stored or balanced with offsets, such as planting trees and protecting nature. Now, while the court found that Shell is not currently acting unlawfully, and you might think Shell heaved a sigh of relief, it ruled that Shell must reduce the carbon dioxide emissions of the Shell group operations and energy carrying products by 45% by the end of the year 2030 compared to its emissions in the year 2019. What legal basis is there, do you think, for the court to make such a ruling over Shell? The Dutch court has jurisdiction over Shell because it's headquartered and its principal place of business is located in the Netherlands. The court based its findings on an unwritten law which is familiar in the law all over the Commonwealth. The court said Shell had an implicit responsibility to prevent harm, a duty of care. The court also regarded climate change as a human rights issue. The court stated that it is universally accepted that all businesses must respect human rights. Each business must check whether their business activities cause any actual or potential negative impacts on human rights. These can be caused by their own activities or in their business relationship with other businesses in what's known as the supply chain. As you know, the common supply chain begins with the sourcing of raw materials. The raw materials are then taken by a logistic provider to a supplier, which supplier acts as the wholesaler. The materials are then taken to a manufacturer that processes them into finished product. The product is then sent to a distributor, which sells the finished product wholesale, which is then delivered to the retailer. The retailer then sells the product in a store to the consumer. Once the consumer buys it, this completes the cycle. Hence, all businesses involved in the supply chain cycle have a duty to adhere to human rights policies. The court said that the consequences of climate change in the Netherlands and the Wadden region, which, as you know, is a set of islands and a body of water near the North Sea, pose a threat to the human rights of Dutch residents and the inhabitants of the Wadden region. Now, what are the broader consequences of this Netherlands court order globally and for other companies and potentially in other jurisdictions outside of Netherlands? The impact of this order is catastrophic. It's earth-shattering. It's massive. For the first time, the duty of care or similar obligation of a globally operating company has been interpreted to include human rights impact of climate change and more generally the soft law implications of global international treaties like the Paris Agreement. The court demanded that a global company like Shell fulfill its obligations under the Paris Climate Agreement, as you know, which Trump denied, which is a legally binding international treaty on climate change, even though Shell was not a party to that agreement. This includes other soft law rules such as the ILO core labor standards, which, as you know, is a set of 4 fundamental, universal and indivisible human rights. The first is freedom from forced labor. Second is freedom from child labor. The third is freedom from discrimination at work. And finally, the fourth is freedom to form and join a union to bargain collectively. Other soft law rules include the United Nations Guiding Principles for Businesses and Human Rights, which is, as you know, a set of guidelines for states and companies to prevent, to address, and to remedy human rights abuses committed in business operations, and the OECD guidelines, which are a set of standards for responsible business conduct across a range of issues such as human rights, labor rights, the environment for all multinational companies. These rules define a company's responsibilities, which are independent from what states or nations have to do. Similar cases will probably follow soon, not just in the Netherlands, but across the world, in India, in China, in Malaysia, in Singapore, in Australia, in New Zealand, Tasmania, in Europe, all over the world. Investors will also be affected, first as shareholders and lenders to these companies, and second, because what applies to companies will be applicable to, you guessed it, institutional investors. Looking at the ripple effect of these outcomes, global standards might no longer be optional for companies to ignore with impunity. Therefore, investors should take precautions by considering these factors before making any decision to invest in a company. And there I leave you. Good day.